he argues that aside from Rule 26, there are other hypothetical grounds upon which sanctions might be granted, right? And... okay, I think I get it. Okay, so the rest of the document reads as follows. There is no history. Dave Neal is just one of the most obsessed followers of this case. It's almost like he has nothing else going on in life, which is sad since the case ends in less than 3 weeks. Dave Neal is a new father, you fucking twat. Look, I don't want to criticize David personally, and I don't want to call him names, but it slips out a little bit sometimes when he makes things personal. Good morning, everybody. Welcome back to the internet, where your cesspool is my jacuzzi. My name is Lauren Knighty, and I'm going to read the latest Twitter filing in the Clayton Echard Laura Owens paternity scandal so that you don't have to. At the end of summarizing this, I'm going to read some of the bizarre new tweets the lawyer has posted since. Last night, Mr. Gingers posted a link to his filing reply in support of petitioner's motion for judgment on the pleadings and renewed motion to dismiss. Yesterday we saw documents in which the court had ruled on multiple motions in this case, but I believe Ms. Owens and Mr. Gingras had the right to file this reply before the court rules on this motion. Ms. Owens' motion for judgment on the pleadings deals with one narrow and discrete question of law. What are the procedural requirements for imposing Rule 26 sanctions? That primary legal question leads to a secondary question of fact. Were those procedural requirements followed here, and if not, what effect does that have? Mr. Echard's response offers a bait-and-switch argument, i.e. he argues that aside from Rule 26, there are other hypothetical grounds upon which sanctions might be granted. That's entirely true. Okay. Mr. Echard then argues because there are other legal avenues by which a litigant might hypothetically be sanctioned, it is irrelevant whether Mr. Echard complied with Rule 26's procedural requirements because sanctions could be ordered by some other authority. Mr. Echard also claims he more or less did everything Rule 26 requires. Therefore, sanctions could still be awarded under that rule. To me, it seems like we're still beating the dead horse where David is like, this is the only avenue where you would get sanctions and you didn't do this correctly. I feel like this has been thoroughly addressed and debunked at this point. To that last point where they're saying Mr. Echard also claims he did everything Rule 26 requires, so sanctions could still be awarded under that rule, I feel like they addressed that in the original response to the original motion here. I said this last night when I was reading this whole thing live, but I feel like when I'm reading his filings, I'm like being gaslit by what he's writing. I feel like if he thinks he argues the same point over and over again, it might stick, whereas he's not really responding to the arguments that Clayton and Woodnick were making. These arguments completely miss the point. As explained in Ms. Owens' motion, it is undisputed Mr. Echard did not comply with any part of Rule 26's procedural requirements, and this court cannot, as a matter of law, overlook those mistakes by converting the now withdrawn Rule 26 motion into a request for any sort of alternative relief. Also, because there are no other actual sanctions motions pending, and because the defective Rule 26 motion precludes any other alternative relief, such as a sua sponte award, the net result is that there is nothing further for the court to decide with respect to sanctions. Accordingly, Ms. Owens is entitled to judgment as a matter of law on that issue. This is where I'm going to stop reading word for word, because I'm going to try to sum it up a little bit. The whole purpose of me doing this after, I read the whole document last night is that I know a lot of people don't have time to watch or listen to the 30-minute video that I did last night, so I'm trying to make this a little bit quicker. Plus, I'm sure that Dave, Megan, that Umbrella Guy, Meg's Crime Watch, a whole bunch of other people are going to do their own analysis of this where they'll probably go through the whole thing and can break all that down for you. The issues raised in petitioner's motion are not moot. To begin, Mr. Echard suggests Ms. Owens is not entitled to judgment on the pleadings as to the issue of Rule 26 sanctions because he deems that issue moot. This argument is simply wrong. The record is clear. Mr. Echard filed a previous Rule 26 motion, which he moved to withdraw on April 3rd, 2024. Despite asking the court for permission to withdraw the Rule 26 motion, that request was not granted until a matter of days ago via minute entry order dated May 17th, 2024. Thus, at the time Ms. Owens' motion for judgment on the pleadings was filed on May 15th, 2024, Mr. Echard's Rule 26 motion remained pending and was not moot. So let's look at what he's referring to here, because in my opinion, this is just like a surefire way to piss off the judge. Respondent's motion for sanctions pursuant to Rule 26 filed on January 3rd, 2024 is hereby withdrawn. Let the record reflect, due to clerical omission, the ruling was not issued. Additionally, the court originally issued the ruling on April 4th, 2024. By what that other document is saying, it's like the court granted the motion to withdraw 1 day after it was filed, and they filed a non-objection. Back to the shit show. Furthermore, even though this court later granted Mr. Echard's request to withdraw his Rule 26 motion after Miss Owens' present motion was filed, Jesus Christ, that still does not mean the issue of Rule 26 sanctions is moot. Here we go again. This is because A, Mr. Echard specifically and separately made a request for Rule 26 sanctions in his amended response to petition to establish paternity filed January 26th, which he has not withdrawn, and B, because Mr. Echard appears to still be seeking sanctions on some other related but unidentified basis, presumably based on the court's sua sponte authority under Rule 26. Indeed, on page 7 of his now withdrawn Rule 26 motion, Mr. Echard suggested this court could and should award sanctions on the court's own impetus under Rule 26. That specific argument, repeated in other pleadings, is shown below. Why does this matter? It matters because, as explained on pages 9 to 10 of Ms. Owens' original motion, when a party seeks sanctions under Rule 11 or 26 but then fails to comply with the rule's procedural requirements, the court cannot fix the problem by converting the defective Rule 11 motion into an alternative request for sua sponte sanctions based on the court's own initiative. This is simply not permitted. I think it's kind of nice of him to let the judge know what is and is not permitted. Based on the authority cited in Ms. Owens' motion, this court cannot do what Mr. Echard asks. It cannot convert his defective and now withdrawn Rule 26 motion into a request for relief under some alternative theory. The court cannot do this because if it did, this would render Rule 11 safe harbor provision meaningless to permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. I like how it was clearly explained in Woodnick's filing that you can't just use the safe harbor provision as a get-out-of-jail-free card for filing frivolous petitions. But here we're going to ignore that point because that's inconvenient. To be clear, if Mr. Echard will stipulate that this court cannot sanction Ms. Owens sua sponte, then Ms. Owens will agree that the issue is moot. But Mr. Echard has not taken that position. Very much on the contrary, he's made it clear that he will stop at absolutely nothing under any circumstances until every possible argument in favor of sanctions has been litigated and resolved. Okay? Because Mr. Echard has taken this position, the issue remains ripe for this court to resolve, and as explained in Ms. Owens' original motion, Mr. Echard cannot obtain sanctions under Rule 26 because he failed to follow the requirements of that rule, and by necessary extension, that error precludes the court from stepping in to help by converting the motion into one seeking relief under any other alternative theory. This issue is not moot, and for the reasons already explained, Ms. Owens is entitled to prevail on that issue as a matter of law. Mr. Echard misstates the holding of Holgate v. Baldwin. Strangely, immediately after claiming that Rule 26 issue is moot, Mr. Echard then proceeds to argue he complied with Rule 26 and thus sanctions are still available under that rule. I don't think that's what they were saying. Somebody correct me if that's what they were saying, but I don't know. No. The effect of this holding is simple. If a party prepares and serves a valid safe harbor warning notice, something Mr. Echard admits he never did, that's definitely not what happened. And that party moves for sanctions which is denied without prejudice, the party is not required to prepare a second safe harbor notice before filing a second or renewed request for sanctions. The law merely requires that one warning be given, and in Holgate, the court correctly found the required notice was given. Holgate does not support the argument that a party like Mr. Echard can simply ignore the safe harbor warning altogether. Literally no part of Holgate even remotely suggests this. Literally no part. For those reasons, nothing about Holgate helps Mr. Echard. In this case, Mr. Echard admits he never gave the mandatory 10-day safe harbor warning. That is not what happened. That's not what happened. Is that what happened? Somebody tell me if that's what happened. I don't believe that's what happened. The court cannot award sanctions based on some other hypothetical grounds, but even if it could, any other future request for sanctions is untimely. This again. Jesus. On pages 5 to 8 of his response, after flip-flopping between admitting he cannot receive Rule 26 sanctions and then arguing such sanctions are still available, Mr. Echard suggests the court should allow the issue of sanctions to proceed because Rule 26 is just one avenue for sanctions. Okay. As to this issue, Ms. Owens offers 3 short comments. First, to state the obvious. As a matter of basic due process, Mr. Echard cannot obtain sanctions on some imaginary or hypothetical basis that he has never actually pleaded. In other words, it does not make any difference that there are rules or laws other than Rule 26 under which a litigant might be sanctioned, because here Mr. Echard has not moved for sanctions under any authority besides Rule 26. What the fuck? Even the loosest definition of due process mandates that if Mr. Echard wants to obtain such relief, he must actually apply to the court for such relief, and he must explain the factual and legal grounds upon which the request is based. Although the court has extended a great deal of flexibility to Mr. Echard thus far, this much is clear. The court cannot simply wave a magic wand in the air and declare to Miss Owens, "I hereby sanction thee." What are you doing, bro? This leads to Miss Owens' second comment. Mr. Echard's other authority argument ignores a classic limitation imposed by Arizona law. When a statute creates a right and also creates a remedy for the right created, the remedy thereby given is exclusive. What this means is simple. Rule 26 creates a right to seek sanctions anytime a litigant breaks the rules by inter alia, bringing a claim they know is groundless. In addition, the rule provides a clear and powerful remedy to anyone harmed by a violation of that rule. But the remedy established by Rule 26 requires a party seeking relief to follow the specific protocol established by that rule, which Mr. Echard did not do here. This failure is wholly conclusive of the issue of sanctions insofar as it is based on the allegation that Miss Owens filed or pursued this action without a valid basis. Even assuming that is exactly what happened here, Rule 26 provides the exclusive remedy for those violations. Okay. And because Mr. Echard is not entitled to relief under Rule 26, that resolves the issue as a matter of law. At the same time, and to be clear, Miss Owens agrees there are other legal rules/authorities that permit an award of fees for reasons other than a Rule 26 violation. The fact remains a violation of Rule 26 can only be remedied by the process set forth in Rule 26. That rule creates a right and a remedy for any violation, and that remedy is exclusive. There is no dispute the process required by Rule 26 was not followed here. This leads to the third and final comment. As explained on pages 10 to 12 of Miss Owens' motion, any request for sanctions, regardless of the basis, necessarily includes a temporal limitation, i.e., the request must be brought as close as possible to the alleged violation in order to promote the purposes of sanction, i.e., judicial efficiency and avoiding needless litigation. Avoiding needless litigation. That's cute. Mr. Echard never even attempts to respond to that issue in his pleading, so the court should find, as a matter of law, that no other timely basis exists that would permit such a belated request for sanctions made months after Miss Owens had attempted to dismiss the action. I feel like this didn't really address anything of substance in the response, so I'm a little confused by that. But maybe it's not supposed to make sense to me. So if you have any experience in the legal profession, or if you're any kind of law clerk, anything like that, and you have some input, I'm always happy to hear it in the comments below. Somebody on Twitter had responded saying, basically, read Woodnick's responses the first 2 times you tried this, never mention Rule 26 sanctions again. David says, you completely don't get it. Woodnick is still asking for sanctions. Do you think he's not? What's the trial for then? Just for show? Until he permanently withdraws any and all sanctions requests, I'm entitled to an order resolving that issue, and I won't stop until that's done. The stalking comment was a joke. Fact, I'm terrible at comedy. There is no history. Dave Neal is just one of the most obsessed followers of this case. It's almost like he has nothing else going on in life, which is sad since the case ends in less than 3 weeks. Dave Neal is a new father, you fucking twat. Look, I don't want to criticize David personally, and I don't want to call him names, but it slips out a little bit sometimes when he makes things personal. My personal favorite was his response to somebody pointing out that the court issued the withdrawal of Rule 26 sanctions on 4/4/24, and it was a clerical error that had only entered the record on 5/15. David says, the judge's clerical mistakes are not my fault. That's gonna go well. When that motion for judgment on the pleadings was filed, there was a live pending Rule 26 motion. It had not been withdrawn, and I could not just assume the request to withdraw it would be granted. Mata could have denied it. Listen, I understand that, taking that point of view even, but don't tweet shit like the judge's clerical mistakes are not my fault. That is not gonna go over well. Alright, I gotta go make sure my homework is filed in a timely manner.